Justice YV Chandrachud took charge as the 50th Chief Justice of India today. Justice Chandrachud, the son of India's longest-serving Chief Justice YV Chandrachud, was administered the oath of office by President Droupadi Murmu at the Rashtrapati Bhavan this very morning. This marks the first instance of a father and son duo heading the Indian judiciary. Justice Chandrachud's father, Justice YV Chandrachud, was the 16th Chief Justice of India, serving from 2nd February 1978 to 11th July 1985. The former CJI UU Lalit had recommended the name of Justice Chandrachud as his successor on October 11th this year, which the President accepted on October 17th. Justice UU Lalit demitted office on Tuesday after a brief but effective tenure of 74 days. The senior-most judge of the Supreme Court of India, Justice Chandrachud, is set to serve as the Chief Justice of India for a period of 2 years until November 10, 2024, making it one of the longest terms for a CJI in the recent past. Born on November 11, 1959, Justice Chandrachud graduated from St. Stephen's College in Delhi with a degree in economics and mathematics in 1979 before obtaining a bachelor's degree in law from the Faculty of Law at Delhi University in the year 1982. He then went on to pursue an LLM from Harvard University in the United States after obtaining the prestigious INLAC scholarship, and he also received the Joseph H. Beale Prize for securing the highest marks in the Conflict of Laws course. Pertinently, he then went on to obtain a doctorate in juridical sciences from Harvard University as well, pursuant to which he enrolled as an advocate with the Bar Council of Maharashtra. Justice Chandrachud was elevated to the Supreme Court of India on May 13, 2016. Prior to that, he had served as the Chief Justice of the Allahabad High Court from 31st October 2013 onwards until his elevation to the Supreme Court. His judicial career began with his appointment as a judge of the Bombay High Court on 29th March 2000. He also served as the Additional Solicitor General of India from 1998 until his appointment as a judge. He was in fact designated as a senior advocate by the Bombay High Court in the year 1998, despite being only 38 years old, as this designation is rarely given to advocates below the age of 40 years. Justice Chandrachud is well known for his liberal and progressive judicial pronouncements, the most recent one being the verdict which expanded the scope of the Medical Termination of Pregnancy Act, that is the MTP Act, and its corresponding rules to uphold the rights of unmarried women to seek abortion of pregnancy up to 24 weeks. Further, in a much-needed acknowledgement of marital rape, Justice Chandrachud had noted that for the sole purpose of the Medical Termination of Pregnancy Act, the meaning of rape must also include marital rape. He was also a part of several constitution benches which delivered some landmark judicial pronouncements. Back in August 2017, he was part of the 9-judge bench of the Supreme Court, which unanimously affirmed that the Constitution of India guarantees a fundamental right to privacy in the landmark case of K.S. Puttaswamy versus Union of India. Interestingly, while authoring his separate but concurring judgment for this landmark verdict, Justice Chandrachud had overruled a widely criticized verdict passed by his own father, that is former CJI YV Chandrachud, in the ADM Jabalpur case, which had placed riders and regulations on the right to liberty. Overruling the ADM Jabalpur verdict, Justice Chandrachud wrote, and I quote here, "The judgments rendered by all the 4 judges constituting the majority in ADM Jabalpur are seriously flawed. Life and personal liberty are inalienable to human existence." Subsequently, in the year 2019, maintaining his dissent from the majority in the Aadhaar case, Justice Chandrachud, as a sole dissenter, ruled that the Aadhaar Act of 2016 had been unconstitutionally passed as a money bill. He had also highlighted key provisions of the Act to be violative of an individual's privacy, dignity, as well as autonomy. In the renowned case of Joseph Shine versus Union of India, Chandrachud concurred with the majority opinion in decriminalizing adultery. He was of the opinion that criminalizing adultery was rooted in patriarchal notions and had resulted in centuries of female subjugation. Furthermore, in the case of Indian Young Lawyers Association versus State of Kerala, popularly known as the Sabrimala case, Justice Chandrachud held that the exclusion of women between the ages of 10 to 50 years from the Sabrimala temple violated constitutional morality. Justice Chandrachud also wrote a separate concurring opinion in the landmark case of Navdeep Singh Johar versus Union of India that decriminalized Section 377 of the Indian Penal Code and made same-sex intercourse legal. Justice Chandrachud had written a separate concurring opinion. He had labelled Section 377 of the IPC to be an anachronistic colonial law which violated the fundamental rights to equality, freedom of expression, life and privacy. Upholding an adult's right to make decisions in a marriage and also the choice of one's religion, Justice Chandrachud, while delivering a concurring opinion in the case of Safin Jahan versus Ashokanan KM, had held that Hadia's choice of religion and marriage partner falls within the ambit of right to privacy. For context, Hadia had converted to Islam and had married the petitioner in this case, that is Safin Jahan, pursuant to which her parents had sought the court's intervention. Importantly, Justice Chandrachud also dissented while delivering the judgment in the case of Romila Thapar versus Union of India regarding the arrest of 5 human rights activists for allegedly instigating violence at Bhima Koregaon and participating in a criminal conspiracy against Prime Minister Narendra Modi. While opining that the investigation must be transferred from the Maharashtra police to an SIT constituted by the court, Chandrachud had flagged that voices of opposition cannot be muzzled because it is a dissent. He has also been a champion of furthering causes of personal liberty. Deprivation of liberty, even for a single day, is one day too many, he had famously said in the Arnab Goswami case, which we are well aware of. Recently, in fact, in the Muhammad Zubair case, Justice Chandrachud granted relief to the journalist after noting that he was trapped in a vicious cycle of criminal process. Another notable intervention of Justice Chandrachud are the orders passed in the Suomoto COVID case, where the Supreme Court of India had cast aspersions on the vaccine policy followed by the union government. In fact, after the bench led by Justice Chandrachud raised certain strong questions and even asked the government to show details of the utilization of its budgetary allocation for the procurement of COVID-19 vaccines, the central government had subsequently changed its vaccine policy. However, some of his judgments have not been as well received. He was the author of the judgment which had ruled out foul play in the death of Judge B.H. Lawyer, who was holding the trial against Amit Shah and others in the Sohrabuddin fake encounter case. Justice Chandrachud was also a member of the 5-judge bench which decided the Ayodhya Babri Masjid case. Widely known as someone who favors technological advancement to aid the dispensation of justice, Justice Chandrachud, as head of the Supreme Court's E-Committee, has also been credited for putting in place a robust system that has worked well during the COVID-19 pandemic by ensuring that courts in our country turn to the virtual mode, thereby increasing accessibility and transparency of judicial proceedings. On November 3rd this year, in fact, Justice Chandrachud, while heading a bench along with Justice Hema Kohli, said that efforts are on to set up a national infrastructure where proceedings in all courts, from subordinate courts to high courts and the Supreme Court, can be streamed live from a single national platform. Chandrachud is also widely popular with the younger generation, especially amongst law students and young advocates. On earlier occasions, while delivering lectures, Justice Chandrachud has called upon law students to strive to adopt a legal approach that puts the daily lives of people at the very center. Recently, in fact, while delivering the convocation address at the National Law University of Delhi, Justice Chandrachud advised young law students to incorporate feminist thinking in the way they deal with the law. This very perspective is in fact evident in the judgments authored by him as a Supreme Court judge, especially in the case of Lieutenant Colonel Nitisha versus Union of India, where he recognized the concept of indirect discrimination and held that women should be considered for receiving permanent commissions in the Indian Army. Great expectations lie ahead of Justice Chandrachud, and hopefully we will witness a grand tenure that upholds the fundamental ethos of our Constitution. Thank you. I'm Rashtrapati Bhavan for LiveLaw. Keep watching LiveLaw for more updates.